Court is now in session.
Thank you. We are on the record in Augee. I hope I'm pronouncing that right, but if I'm not, I'm sure I'll be corrected. Augee v. Wright. This is CV20 0154. This is the date and time set for oral argument. A couple of housekeeping matters as we get started here. In a different time, you'd be invited to stand at the podium here, and you'd have a clock there in front of you. You'd know right where you were at with your time. Today we'll invite you to stay seated where you're at. If you need to glance over that podium clock, you're welcome to do that. We are, the panel, we're not wearing masks because we're socially distanced, and you already have your masks off, which is fine if you're comfortable with that. With that, are we ready to proceed?
Yes.
Okay.
Yes, sure.
Council will invite you to just state your name and who you represent as you begin, and go ahead.
May it please the court, Keith Berkshire for the appellant, Matthew Augee. I think you were close enough.
Got it right. We're off to a good
I don't
start.
know, and we're both wrong. So the issue, as is apparent from our brief, is the question of whether the court adopting a decree based on a Rule 69 agreement was appropriate, when in our position there was a condition precedent that needed to be met before the decree could be entered or before the agreement became essentially a binding agreement. And as is apparent from the brief, the issue is whether this foundation that my client was part of signed a release, which was the condition before the agreement essentially became binding. I want to start with, there was a question of whether finality of judgment issue from the decree signed under Rule 81 versus 78, and which were appealing under when my client filed his pro per notice of appeal, he filed it based mainly on the motion to set aside. I don't think the issue really, frankly, makes much of a difference if it was just on the motion to set aside versus the motion to set aside and the decree. Because of the procedural posture of how this case got here, which is kind of strange if you look at what the judge ruled. Initially, he had said in an evidentiary hearing on the issue of whether the agreement was going to be met. He then vacated that, said an oral argument, stated at the oral argument he was going to specifically decide whether he found that my client had the authority to sign the release, didn't find that.
Counsel, would you agree that if your client was an agent for the foundation, he was authorized to bind the foundation during that Rule 69 colloquy and proceeding at the settlement conference?
It would depend on what the foundation's rules were on how many people it took to bind it. And that was one of the disputes when Mr. Willencheck showed up at the telephonic status conference. There was a discussion about, no testimony essentially, but a discussion of the attorneys of how many people it took on the board to actually bind to bind this agency to the terms. So it wasn't, according to Mr. Willencheck, it took more than one party.
I guess my question wasn't precise then. If the foundation had made him an agent for purposes of negotiating this settlement, so if he was authorized as an agent of the foundation for that purpose, then there wouldn't be an issue.
If the foundation had done a vote that says for this purpose, on this date, he can make this bind the foundation, I'd completely agree with you.
Okay.
That would be, though, to determine that, I think would have to be a factual issue that would require a hearing. The court didn't do that.
And that's what you're asking for. That's all you're asking for here in this appeal.
It's somewhat two parts. To find if he had the authority as an agent to bind, we believe would require a hearing. We also believe that in a separate issue of whether the Rule 69 matched the decree would require a hearing. So I think it's...
Let me then back up on that. On that separate issue on whether Rule 69 matched up with the decree, why is that matter for your client?
I'm not following.
Okay. Regardless of what the court orders the foundation, and who knows whether the court has authority to order the foundation to do anything, but the agreements, the portions of the agreement relative between your client and the wife, those didn't change.
Well, it did somewhat, because until the foundation signs the release, my client doesn't get certain property back. And so essentially, if the foundation never signs the release, there's certain things that he would never get back.
Right, but once the court said you're going to sign, your client's going to sign the release, and then the rest of those terms, which you guys had all agreed to at the settlement conference, are in force.
Assuming that my client signing the release, the court orders it, assuming the wife would actually accept that that was a release by the foundation, because until the foundation signs the release, then she doesn't have to return the property. I mean, you could order.
My question kind of is, I agree the foundation seems to be an aggrieved party, and to tip my hand, I don't see that the court has any authority to bind the foundation, and I don't know what authority the trial court's release that they're ordering your husband or your client to sign on behalf of the foundation will have in respect to future litigation. There doesn't seem to be privity. There's a whole bunch of issues that will probably be litigated in a future case. But I don't see what harm there is to your client by the trial court's order.
Again, the harm is that unless the foundation signs the release, wife doesn't have to give the property back. So if wife could easily say, well, the foundation hasn't released it.
The trial court said, husband, you're going to sign the release on behalf of the foundation, and wife, you're going to return the property. That's how I read the decree.
Okay.
Do you disagree with that reading?
I guess I don't, assuming that that my client is willing to sign something that he has no authority to sign, and essentially then potentially creates issues between him and the foundation. Again, I don't know if it really matters from that standpoint, because he could have there could be any number of conditions in a Rule 69 agreement that the court doesn't get to necessarily modify. It doesn't really matter the severity of the issue. This was their agreement. The foundation has to sign, and then the agreement is effective. It could be anything. I mean, you could have a ridiculous condition precedent that has no real material value, but it's still a condition that the parties agreed to. So that is one of the things, that unless the foundation signed, and my client, made that a condition. It's very clear in the meeting or in the ADR with Judge Hilliard that was a condition. That I don't think the materiality of it to my client is really legally dispositive. I think the issue is checkbox was not met. There is not an agreement.
Mr. Berkshire, so just so I am clear, you're not asking us to decide whether or not your client was an agent authorized to sign the document. You're simply asking us to remand this to the trial court for the court to hold a hearing to determine whether or not he was an agent authorized to sign.
Correct. And if he's not an agent authorized to sign, the decree can't be entered based on the Rule 69 agreement.
Is there any place in the record where your client asserts that he's not authorized to sign? I mean, is there anything during the negotiation, et cetera, where it illustrates that it was going to require further action from the foundation to effectuate this agreement?
I think there is. And if you look if you've read the transcript of the Rule 69 agreement in front of Judge Hilliard, former Judge Hilliard, they go through and he gets this property. It's a massive property list. But one of the things that is then very clear is he constantly refers to that the foundation will need to approve. Upon approval of the foundation, he refers to them as they in the transcript there, that once they sign or once they approve, it's not me. And he said that, because there's a question, I believe, from Judge Hilliard asks, do you think they will? And he's like, yes, I've discussed it with them that I believe they will. It's not ever in that I can sign for the foundation. He refers to the foundation as a separate entity in the transcript on those pages. It's page 18 to 19 and page 12 that talk of that first, the Rule 69 transcript, where he refers to them as a different party. And then in the objection to the decree, he refers to them that they need the approval. And even in the motion to set aside, again, that they need to approve. There's nothing, I think, to go to the opposite, there's nothing in the record that says I have the authority to approve this, because if he was going to approve it, the Rule 69, why would it be contingent? I will sign the release. There's no logical reason that it would require this if the foundation approves, if they approve, because he'll just be like, he could just say, I have the authority to sign the release today. But he refers to another person, and it's also not contested that there was another person from the foundation outside the room during mediation so that he could talk to them about this process. There's nothing in the record. Again, I think it would be back to your question, Judge Campbell, if we need a hearing on that. I think that is important for a hearing, that they need to take evidence about whether he had the ability to sign this.
But you agree that this court isn't in a position to reweigh that and make that determination?
I don't think there was anything in the record from a fact basis that this court could rely on to uphold the decision, because there was no evidence taken on it. I think that the issue is just, being that it's a fact issue of did he have the authority, this court would remand for the point of saying you couldn't weigh a fact issue without evidence, therefore the trial court needs to hold a hearing on this before they can determine if they're going to uphold the Rule 69 agreement through the decree. I mean, that's the major problem we have here in its multi-steps, is the issue of being that there's a fact issue. I mean, my client raised a bunch of issues in his motion to set aside that where the Rule 69 agreement, he alleges, doesn't meet the decree. Those are fact issues unless they're clear on their face of whether their agreement that's on the record met the decree. And so those are the things that, again, especially in this case, the authority to sign, those are the fact issues we believe require a hearing. I mean, interestingly, one of the cases just came out of this court a few weeks ago. It was mine. We weren't successful on the Solorzano-Jensen case that talked about, you can't do any of this via affidavit, pleadings, anything. If there's any fact issues, you have to hold a hearing, no matter what the parties agreed to the process. It was a child support case. But the point of the case was any of these fact issues, anything that relies on credibility, anything like that, which here, I can't imagine how determining whether or not he was an agent or had the authority wouldn't be a credibility issue or wouldn't be a fact issue. I think in relying on that Solorzano case, again, it would require a hearing, which is what this court did in Solorzano to send it back for a hearing. So I think on that specific question of whether he had the authority, I think that's what would most likely be appropriate, to send it back to a specific evidentiary hearing on that issue. And if he didn't have the authority, I don't see how the decree could be entered, because the Rule 69 agreement conditions wouldn't have been met. And in that, one of the issues of whether the conditions were met is, yes, to some extent, it seems like a small issue of, okay, if he signs this and wife is ordered to give back the property, what's the difference? But the court doesn't get to do that. They don't get to just say, hey, well, this condition isn't important, this term of your agreement isn't important. It's, you don't have as this court said in the Engstrom case, the statute of the rule don't vest the court with the authority to modify an agreement at all. They have an agreement. This is the terms. The court's job is to interpret it and to see if it was met, see if it was effectuated, not to weigh that this was important or not. Was the agreement met? If not, you don't get to enter it. You don't get to rewrite the contracts that the parties had. In the Rule 69 agreement, they're interpreted the same as any other contract. They're interpreted the same as any other agreement, and they have to, the decree has to match that. And again, we don't believe that it matches it because of this one condition. And back to the issue of this telephonic status conference not being a hearing, again, there was, we had letters from the foundation and from their lawyer saying that they had no authority to do this and these types of things that were never, again, ruled on. And I think it's one of the most concerning things is the court did say that it was going to do some sort of ruling on this authority issue. And so the fact that the court never actually explicitly did it, they just entered the decree. The procedural process was, of the motions and the objection was, the court changed its mind multiple times of how it was going to deal with this. I think the first inclination of Judge Driggs was probably accurate, was probably the appropriate thing, which was to just set an evidentiary hearing. That was the first thing. Then my client filed to continue it because of some medical issues. Then the court just said, no, I'm vacating the hearing on its own directive, vacated the hearing and set an oral argument on this issue. Yet I think the initial inclination of the court was correct. Factual issue, credibility issue, and the only way to deal with that is some sort of evidentiary hearing so the parties can both present what they have. I'll save the rest of my time for...
Looks like you've got about
6
minutes and 41 seconds.
It's easier when you switch the clock so we can...
Yeah, noted.
If the court, good morning, Gary Rosser on behalf of the appellee Patricia Wright. I didn't have to say her last name the other way, so, but it is Augee, not Augee. But If the court doesn't mind, I'm going to use the timer on my phone just so I can see it.
As long as you acknowledge that the timer appears controlling, so in case you're using some kind of non-Swiss timepiece there.
Well, you know what, I can't even get to start, so we'll just play it by ear. So the first thing I want to clarify, appellant's argument was that there was a condition precedent that was not met. And I would agree there was a condition precedent, but the question is a condition precedent to what? So the release did not have to sign, in their brief, they say the release had to be signed for the agreement to even be effective, which is not what they agreed to. And in the decree, it says that my client doesn't have to release the property until the release is signed. Now, whether that release is effective or not, I think Judge Morse may be correct. That may be decided by another court at a later date. But he had the authority to bind the foundation because...
Isn't that the whole question, though? Did he have the authority to bind the foundation?
All you have to do is look at the transcript, and in fact, he offers it up. So if we look at pages...
Let's break that down, because I could say I have the authority to bind all three judges on this panel. It doesn't matter what I say. It's have they in some way conveyed that authority upon me to bind all three judges on the panel. So why does it matter what he says?
Well, he had at least apparent authority because he had...
Okay, so there's three types of authority. There's actual, apparent, and applied, which is, I'm not sure what the difference is between implied and apparent, but that's a different question for another day. So did he have actual authority? Because I see no evidence in the record of actual authority.
If you read the transcript, I believe that it conveys, that he conveys that he has actual authority.
Okay.
Because he says on page 19 of the transcript that he had discussed with the board. He was not voting on this issue, but he had discussed with the board, and he discussed in advance what our option would be and choices. So my agreement to it is following their decision. And the fact that there was a board member there would lend credibility to my client's.
Actual authority is authority that's actually conveyed. Sorry, did I interrupt you, Judge Campbell? Okay. Actual authority is pursuant to the legal document setting up the board that he is either has some type of actual delegated authority, right?
Right.
Okay. So what you're saying is there's either apparent or implied authority there from his statements indicating that the board had done that.
Right.
Okay.
If you accept his statements as true, then he has actual authority because the board has told him you can do these things.
If they actually did it.
Right.
But there would still need to be fact-finding to determine if they'd actually done it.
Well, and he's testified under oath on the record that, in fact, they've discussed it, and he's proceeding according to their
And he may be lying,
decision.
so maybe there would still need to be fact-finding to determine if that's actual authority.
It's actual authority.
Okay.
But below that, I would say below that he clearly had apparent authority because of the fact that there was a member of the foundation there that he was allowed to confer with, and he came in.
Doesn't the agreement that he entered into on the record say subject to the board's approval?
No.
It doesn't?
It doesn't. He says, again, at page 19 of the transcript, he says that they had discussed it, what the options were, and his agreement to it is following their decision.
Okay, go ahead.
So again, going back to where I started, the condition precedent isn't to make it a binding agreement, but rather whether or not they comply with that condition so that he can get his property released. He's the one that's actually ordered to comply with it. He, as an officer of the, and he represented, I believe that he was an officer of the foundation, or the court found it, and so he would have the authority to sign an agreement that was made by the board outside of his presence. he would have the authority as an officer to sign off on that if they gave that to him, which, again, he says that they did. So he clearly had, he clearly had at least apparent authority that my client relied on, because it was actually the appellant that kept dragging in all of these assets of the foundation and wanting to make them part of this dissolution. And so out of just a desire to get the matter completed, we incorporated the disposition of those assets in the decree. You could carve those out and say, those don't matter. He signs the release. It may or may not be effective.
So hypothetically speaking, he does sign the release.
Right.
And he didn't have authority to sign it. What's the repercussion for the parties in that given scenario?
The repercussion is if the foundation brings a action against my client, then it's possibly not effective as to my client. She doesn't have a release of claims from the foundation.
So what would the repercussions be for Mr. Berkshire's clients?
None. If they did not give him the authority to do this, assuming that they didn't, and assuming that you can't find that he had apparent authority to do it, then they wouldn't be bound by the release. But that's in a different piece of litigation later. All that is a trigger. The getting the release signed is just a trigger to, and there were actually two releases that needed to be signed, one individually by the appellant and one on behalf of the foundation. Once he signs and delivers those two, that triggers the release of the property.
So you're saying basically that the release serves to protect your client from his client and from the foundation. I'm just confused. If it's not that important, why are we here?
Well, when I was actually sitting in the room, so and it's reflected in the transcript, we believe that he had actual authority to sign this, especially based on what he had said during the negotiations and what we had put on the record.
And I think
And we could have obviously made the record clearer that he had actual authority to enter into this agreement, but by bringing in the board member, but
I'm still hung up on your apparent authority argument.
Sure.
Because it seems to me you're saying when the putative agent says, I have authority, that's sufficient to establish apparent authority? Or is
No.
it the putative agent plus the fact that a board member was outside the room?
Plus the fact that they, in effect, ratified the agreement, or ratified his authority, because what they said in their letter that he attached to his Rule 85 motion, they say that they are withdrawing their agreement to release the, they're withdrawing their agreement.
Yeah, but that was
to enter
entered
into the
long
release.
after, that letter was sent long after the agreement. So how could that letter provide apparent authority at the time the agreement was entered into?
That the fact that they didn't immediately say,
I mean, what are the facts that you're pointing to in the record right now at the time the agreement was entered into at the settlement conference that shows apparent authority?
again, the two main things are that there was a board member that he consulted with throughout the process, and then he, under oath, relayed that he was acting at the behest of the board in agreeing to these things. Now, he wasn't making the agreement itself, he was the messenger, not the negotiator.
So it's his statements and the fact of a board member present is what conveys apparent authority in your opinion?
At that time, but then I think it's bolstered by the fact that they wait for at least 2 months to.
Well, you waited 3 months to submit the proposed agreement, so I don't know how much you want us to consider time.
Well, but because there's a difference. One, they know this decree is out there. or this decree is out there, and that they have to sign a release. They know that. Because they had to know that because they sent the letter saying we're withdrawing that.
Go on.
And so the fact that they waited so long to do that would have, or is evidence that they were ratifying his representation that that they would sign a release.
Does the fact that apparently some of the property that the foundation thought they were allegedly was, taking your version of facts is true, that the foundation gave either actual or apparent or implied apparent or some type of authority to the husband to negotiate for the return of the property. Does the fact that the property has been lost or mislaid or isn't available to be returned anymore, does that undercut it? In other words, if I give Judge Williams authority, you can negotiate for return of that $100,000, and he goes and negotiates for that return of the $100,000, and then it turns out there's only $25,000 left. Well, I didn't negotiate, or didn't give him authority to negotiate for the return of $25,000. I gave him the authority to return all of that money to me. So,
Well,
how
your
does that-
analogy is actually perfect because in this case, if there was property that was not returned under Rule 90 of the family law rules, then they would have been able to enforce that provision.
how could they enforce it? They're not a party to this litigation.
Under Rule 90, it says that a non-party can enforce a provision or can enforce one of their remedies in the same way as a party, and a party can enforce against a provision against a non-party in the same way as if they were a party. So the authority would come under Rule 90.
To do what?
To enforce the return of the property.
But if the property
And if the property's gone, then let's assume for a second that it's husband and wife as opposed to wife and foundation. So if it's husband and wife, if the property's gone, then you would deal with it through some sort of enforcement or contempt proceeding, and there could be damages awarded or some other remedy that would put them in the place that they would have been had the party that was required to do the return.
Does the agreement entered into on the record provide enough specificity for them to be able to do that, for the foundation to be able to do that?
Enough specificity as to what? I'm sorry. I'm not
As to
following.
what is expected to be returned?
Yes, there's a whole list. There's 3 lists.
Right.
Goes to wife, goes to husbands, goes to foundation.
And all those were incorporated into the decree?
Yes,
Okay.
they're all incorporated into the decree, yes.
So then the foundation's claim, at least in that letter that they sent later, that some of that property is missing really doesn't matter because they could sue under Rule 90 or move under Rule 90 to have some type of damages or contempt proceeding or something.
Well, it would be under one of the other rules, but Rule 90 would give them the standing, if you will, to come into the family court and enforce that.
Counsel, isn't that precisely what you negotiated to protect your client from?
Yeah, what does the release do in that case then?
Well, when we're sitting there, the release then settles all claims that the foundation has against her, because there were allegations flying back and forth that, well, this is the foundation property, no, it's community property, it's gone now, we don't know where it is, it's damaged, and I won't get into the details of the specific property, but that was flying back and forth, and so the purpose of this was to say, okay, foundation, you're going to get this, and this is all you're ever going to get, and you're not going to bring a claim against wife. Husband, this is what you're going to get, and this is all you're going to get, and you can't bring a claim against wife for any further property. Wife, this is what you're going to get, and you can't bring, well, she would be precluded under other theories, but certainly I'm sure she would sign a
But you're
release.
pointing to Rule 90, and you're asking for a release of liability on behalf of the foundation towards your client, saying, well, Rule 90 would get you around that. But if you have a release, wouldn't that supersede a Rule 90 action in regard to your client solely?
It would be unlikely to occur because, as to my client needing to enforce it under Rule 90, because, well, I take that back. Under Rule 90, she could have brought an action, a post-decree action to force the foundation to sign the release, yes.
What I'm saying is this. Your client wants to be released by the foundation
Right.
because there's all this property that this couple has amassed while husband and wife were married that belonged to the foundation. So what other cause of action besides return of the property is your client seeking to be protected from?
Well, it depends. There were claims that husband made in a separate civil action, which was dismissed. And the foundation, ironically, never brought an action. But there were claims with regard to conversion as it relates to my client. So it was basically, none of this exists. Civil department, none of the family department documentation exists. The release doesn't exist. The requirement to sign it doesn't exist. The decree doesn't exist. She's converted my property, and here's my list, which I think he attaches to one of his post-decree motions. And I think it was an objection to it might have been an objection to the decree. But his list always reverted back to his list from the petition, the original petition. So we start at the original petition, we negotiate, we think we reach an agreement, we want to make sure we don't have to do this again, so we get releases from everybody who's going to be a party to either giving or receiving property.
I'm sorry, Judge, do you have more? In your answering brief, you compare husband to an attorney for the foundation, and I was a little confused by that. But he's not an attorney, right?
No, he's not an attorney, but
Okay.
the comparison.
So why would in what scenario, or what authority is there for the proposition that a lay person can act as an attorney for another entity and bind that entity?
Not arguing that at all, making the comparison. So the attorney in the Hayes case is nothing more than an agent on behalf of the client. And the client gives him actual authority to go settle the case for $1,000, I think it was. And then he goes and gets $1,200 and comes back and she says, and I think we've all had this happen to us, he comes back and she says, no, I want more than that. So it's not because he's an attorney, it's because he's her agent and she's given him actual authority to do that. He probably has a parent authority because he's her attorney of record. He probably has a parent authority if he says, look, my client's authorized me to make this offer or accept this offer. He probably has a parent authority as to the other side. And in this case, it was a officer of the foundation that was making the same representations as.
But in my record, I don't have the copy of the transcript right in front of me, but my recollection is that on the December 13th transcript of that hearing, that husband said, A, I'm not voting on this member, so I'm not a voting member here for these purposes, and something along the lines of that the release would need to go back to the foundation for approval. On page 24, I believe, is where he says that.
I think that was just a ministerial act because he had already said, again, if you.
Well, that's pretty convenient to describe it as a ministerial act. Approval is generally considered approval. I mean, if he had, your statement earlier was he was authorized to sign on behalf of the foundation, so why would he tell you that it needs to go back to the foundation for approval if he was authorized to sign on their behalf?
Well, signing it after the agreement has already been entered is a ministerial act. If you look at, let's assume an example of you're taking out a loan. A business is taking out a loan and a certain business unit negotiates the loan with the bank and then the documents are drawn up and they come in and some other officer signs on behalf of the party that's getting the loan.
And I think that's where your argument fails, counsel, when you say on behalf of. And you said he could sign this on behalf of the foundation, but he says I need to take it back to the foundation for approval. So it's not the same as getting a loan, because if it's simply signing the document, the loan's already been approved. Would you agree?
Well, I would agree, yes, but I would say in this situation, it's already been approved And he testified that it's already been approved. And his testimony, again, I'll just.
Well, you're picking which testimony. He said two things, apparently. He said one point, the foundation told me I could come here and resolve this, and then later he says, well, but this is going to have to be approved by the foundation. So which one are we supposed to accept?
But we see this all the time in transactional matters.
No,
So-
we don't see it all the time in transactions.
I should say, I see it all the time in transactional matters, where there will be the negotiation of some agreement, and then there will be a written action in lieu of meeting where it will be approved. But that's merely a ministerial act for.
We're out of time, but I'm going to ask you one more question, if I could, Judge Williams. There at least seems to be a conflict within his own testimony. Wouldn't you agree with that? He said one thing, and then later he said needs approval. You want to describe that as a ministerial act, but there's at least some conflict there in that testimony.
I would agree that there is some vagueness there, yes.
Okay.
Counsel-
Don't we need an evidentiary hearing to resolve that vagueness?
I don't think it rises to the level of needing an evidentiary hearing, no. I believe that, that there's enough in both the decree.
His first statement in the presence of the board members should trump the second statement and all the denials later.
Well, and this is all against the backdrop of the court finding that he had authority. It's in the decree.
Okay. I've gone on too long. And Judge
Counsel,
Williams, I
time's
think
up. If you want just a few more seconds for any concluding thoughts, you're welcome to do that. Just briefly.
One of you know an attorney to be brief.
30 seconds.
Okay, so I can't get to anything too much substantive in that amount of time, other than I will do my colleague a favor here and concede his argument that the date started to run on January 15th and not on November 20th when the decree was signed, because it didn't have the Rule 78C language.
Okay.
You guys probably saw a lot of those around that time.
Thank you, counsel. Mr. Berkshire, question as you start off. You got about 6 minutes and 40 seconds. Question for you. To the point that was made, the letter from the foundation that was attached to the Rule 85 motion that says we're withdrawing from our agreement, wouldn't they have had to have made an agreement if they're going to withdraw from the agreement?
I can understand the reading of that, but again, I think that still gets to the issue of was there authority, did he have the authority to agree to it? Was that in the record? That would require a hearing on that issue. I think it still comes to that issue. That would be a factual issue that would require a hearing on that authority. And to Judge Morse's comment about that there was, or question, sorry, that my client might have changed his position during this ADR, and reading it onto the record of, yes, he had the authority or not. I think there's a difference between authority that my client has to bind it and just an assumption that the foundation isn't going to have a problem with it. I mean, you can have this assumption, and I think everybody comes out of this reading the Rule 69 agreement that this was essentially meaningless, that they're going to agree to it. But it does say repeatedly, Judge Hilliard, that's how it's labeled in the transcript, asks, are you confident the rest of the board, I don't know, however many members there are on the board, but that they will affirm this? And my client says, yes, I've already discussed it with them, so forth. But he also says, my agreement to it is following their decision. And at the end of this, when they're talking about the decree, which is page 24, which I think was what Judge Campbell was referencing, it specifically says, we're going to send the decree back and forth, you're going to approve it and send it to Mr. Augee to approve, I guess. But it will not be approved until you get the release. So the issue was that the decree wasn't going to be approved or entered, the entire agreement, until the release was received. So the timing of this was, we could finalize the terms. We're not signing this decree until the release is actually in hand. One of the problems I think that comes down that the question of whether my client is harmed by this, if he just signs the release and does what the court has ordered and so forth, I'd agree with Mr. Osser that the decree does say the court finds he has the authority to do this when there was never a hearing that they could have done that based on it. And page 3 of the decree, there's at the bottom, number N, it says the court finds he has the authority to bind it, and then orders him to sign the release, not only as himself, but as the agent of this company. So, of the foundation, the problem then is he signs this. I mean, you can see this going down the line, fine. He just goes and signs it, tries to get the property back. She then gets sued by the foundation, sues my client for fraud because he signed this illicitly saying he had the authority to do it. There's an indemnification lawsuit down the line that is almost inevitable if he signs on behalf of an agency he has no authority to do because he committed fraud. I mean, the
What
court
difference does it
essentially.
make if there's a hearing that determines he had authority afterwards? I still don't see how that would change anything.
Well, let's say-
Unless you guys interplead in the foundation, they're still not bound by it. They still don't have privity. So
There's still not, but there was at least evidence of whether he had the authority to do it. Again, the issue is just there was no hearing on that issue. I mean, the court ordering him to sign something that he says he can't sign. I mean, say sign over title of the London Bridge, they then sue me because I didn't own the London Bridge when I sold it to him. I mean, that's essentially what this is the court saying you have to do this with no hearing. I'm ordering you to sign this on behalf of yourself and the foundation. It's an order to do both on behalf of himself and the foundation. Can they order it for him? I think so. But for the foundation, you're telling him to do something that he is contesting, and you're telling him to do something that he's contesting where there was never a hearing to determine whether he had the authority. So I think back to one of the first questions was, should we just remand it for a hearing on whether he had the authority? I think that was appropriate. I think the judge was going to do that. It just never occurred. That was, I think, the original thought of Judge Drigg was to do that, but it just got lost in the procedural process of this with continuances and so forth. Unless there's any other questions on anything else.
Okay. Counsel, thank you for your arguments today. You've given us much to think about. We'll take the matter under advisement and issue a ruling in due course, and we are adjourned.
Thank you, Doctor.